Uh, Clear. Today we will start fundamental rights, and fundamental rights is given in part 3 of the Constitution. I told it when I was teaching salient feature of the Indian Constitution. I hope that you might be able to recall that now. Today we will start clear, fundamental rights, and we will be covering from Article 12 to 35. Article 12 to 35 deals with the fundamental rights. And also I have told that fundamental rights have been borrowed from which country? Borrowed from USA. I have told that while I was teaching salient feature of the Constitution. Clear? So you simultaneously while listening the lectures, you should also cultivate the habit how to draw these diagrams for your short notes. Is that clear? So while listening and understanding the lecture, cultivate the habit to draw the diagram which I have been drawing here. That's how you will be able to make a short notes, and that will be easy for you to revise before prelims or mains or before interview. Clear? And I have also told that fundamental right is known as Magna Carta of India. Magna Carta of India. Clear? Fundamental rights are Magna Carta of India. Clear? Also, I have told that fundamental rights are justiciable in nature. Justiciable in nature. What is the meaning of justiciable? Justiciable means any aggrieved person can move to Supreme Court directly in case his fundamental right is being violated. Not through the appeal from lower court to high court then Supreme Court. In case of violation of fundamental right, any aggrieved person can move directly to the Supreme Court. Clear? That's why fundamental right is called as justiciable. And one more important thing, why we are calling fundamental rights as fundamental? Any answer? Why we are calling fundamental rights as fundamental? Why? Remember my first lecture when I was teaching Constitution. What is Constitution? What is? Rules and regulation. Anyone else? See, Constitution is the fundamental law of the land. I have told that in the class. Fundamental law of the land. That is Constitution. Clear? And see, fundamental rights are protected and guaranteed by the Constitution. Fundamental rights are protected and guaranteed by the Constitution. Clear? That's why it is called as fundamental, because fundamental right is protected by the fundamental law of the land. That is Constitution. Clear? Now come to the fundamental right in case of Indian context. Fundamental rights in India. See, for the first time, it was Motilal Nehru. Have you heard the name? Motilal Nehru was the father of Jawaharlal Nehru. And he is responsible for Nehru Report. You might have studied about it in history. Nehru Report. Nehru Report was made by the Motilal Nehru, and Motilal Nehru is father of Jawaharlal Nehru. Clear? So for the first time in Nehru report, he has demanded for the fundamental rights in India. In 1928, when? In 1928, Motilal Nehru for the first time demanded fundamental rights for Indians. Clear? Again, again in Karachi session of Congress. Karachi session of Congress was held in which year? Karachi session of Congress was held in 1931. Clear? And who was the president of Congress at that time? No, Sardar Vallabhbhai Patel. Sardar Vallabhbhai Patel was the president of Congress in that session. In which session? In Karachi session, a resolution on fundamental right was passed. A resolution on fundamental right was passed. Okay. And see the importance of fundamental right, how important fundamental right is. Constitution has separated these fundamental rights in part 3 especially. You can see the importance of fundamental rights, how important they are. They are separately listed in the constitution in fundamental in under part 3. Clear? Now come to what is the difference between the ordinary right and fundamental right. Clear? If we are calling fundamental rights, then there be some difference between fundamental right and ordinary rights, isn't it? So what are those differences? See, the first difference is ordinary rights are protected by ordinary law. Ordinary law. Clear? And fundamental rights are protected by constitution. Ordinary laws, ordinary rights are protected by the ordinary law. For example, right to food. Right to food is protected by National Food Security Act. That is ordinary law. Right to equality. That is protected in Article 14 to 18 given in the Constitution. Clear? The first difference is ordinary rights are protected by ordinary law and fundamental rights are protected and guaranteed by the Constitution. Clear? Now second difference. Second difference is any change in ordinary law, any change in ordinary right can be made by legislature through ordinary law. Through ordinary law. For example, National Food Security Act. You can write here the example of National Food Security Act. Clear? If government want to change anything in this law gives the right to food. That is a ordinary legal law, not backed by the constitution. So if government want to change anything in National Food Security Act, it can simply do it, no? But in case of change in fundamental right, in case of change in fundamental right, we need constitutional amendment. We have to amend the constitution, na? Without constitutional amendment, we cannot change the fundamental right. Clear? And also fundamental rights, while changing fundamental rights, we cannot destroy basic structure of fundamental right. We cannot destroy basic structure of constitution while changing fundamental right. Means parliament cannot bring any change which will destroy the fundamental or basic structure of the constitution. And the concept of basic structure was given by the judiciary in which case? Keshwanand Bharati case in 1973. Clear? Now come to the see. Originally in constitution there were 7 fundamental rights. I am not going to repeat these rights because I have already dictated these rights while I was teaching basic salient feature of the Indian constitution. Okay. But originally there were 7 fundamental rights in the constitution, including right to property. If you want, you can refer to the booklet. Right to equality is from Article 14 to 18. Right to freedom, Article 19 to 22. Right against exploitation, Article 23 to 24. Right to freedom of religion, Article 25 to 28. Cultural and educational right, Article 29-30. Right to property was under Article 31. And right to constitutional remedies under Article 32. But this right to property under Article 31 was deleted in 1978 by 44th Constitutional Amendment. Clear? Because of the large number of litigation in the Supreme Court. Because in India, most of the disputes are related to the land or the property. है ना? अपने गांव में देख लो या कहीं पे भी देख लो. Most of the disputes in your villages or in your city or in your colony would be related to the property dispute or land dispute. So there were large number of litigation pending in the Supreme Court. So at that time in 1978, government decided to delete the fundamental right to property as a fundamental right from Article 31 and place right to property in Article 300A. Write down where? In 300A. Clear? And made it as legal right or constitutional right. So if they will ask the question ki right to property is which right? So it is legal right and constitutional right. Legal right and constitutional right. Clear? Any doubt? Now come to the features of fundamental rights. Features of fundamental rights. See, there are few features which are very important for prelims as well as for mains. So you have to learn all these features which I am going to explain. Okay. First feature is see few articles. Few articles means Article 15, 16, 19, 29 and 30. These fundamental rights are available only to the citizen of India. Clear? You have to learn this. 15, 16, 19, 29 and 30. These are available only to the citizens of India, while other fundamental rights are available to all the people, whether they are citizen, foreigner, or they are corporation or any company. But these 15, 16, 19, 29 and 30, these rights are available only to the citizens of India. Clear? Now second important feature is fundamental rights are not absolute. Not absolute, but qualified. Not absolute, but qualified. And what does it means? Fundamental rights are not absolute but qualified. What does it means? It means that state can put some restrictions on the fundamental rights whenever any condition arise to put the restrictions on the fundamental rights. Clear? And this provision, yeah, this feature is to ensure that there is no chaos or no anarchy in the society. Otherwise, for example, take right to freedom of speech. Suppose constitution had made it absolute, then it might be possible that someone might be abusing you in the name of fundamental right of freedom of speech. Clear? That's why some fundamental rights are not absolute and they are qualified, and state has put restrictions on the fundamental rights to prevent the chaos and the anarchy in the society. Clear? Now come to the next feature, that is, see, fundamental rights under article 20 and 21. Fundamental rights under article 20 and 21 cannot be suspended. Clear? Even during the operation of national emergency. See, I have told in the class that there is provision in the constitution for the suspension of fundamental rights during emergency. Suspension of fundamental right during emergency. And this provision has been borrowed from where? Yes. No. Emergency, provision of emergency is borrowed from Government of India Act 1935. But the suspension of fundamental rights during emergency or during operation of emergency is borrowed from Germany. So you might get confused in the question. The provision of emergency, that is borrowed from Government of India Act 1935. Clear? And the provision for suspension of fundamental right during emergency, that is borrowed from Constitution of Germany, a Weimar Constitution. But even during the operation of national emergency, Article 20 and 21 cannot be suspended. Clear? Even during the operation of national emergency. Now come to next feature, that is Article 19. Article 19 is related to right to freedom. See, this right can be suspended during national emergency, but the condition is that the national emergency must be declared on the ground of war or external aggression. Only in that case, Article 19 can be suspended. Means, if the national emergency is on the ground of, declared on the ground of internal disturbance that has been replaced by the armed rebellion, means President can declare emergency if there is armed rebellion in any part of India or in entire India. So if the national emergency is declared on the ground of armed rebellion, then Article 19 cannot be suspended. But when the national emergency is declared on the ground of war, or external aggression. Clear? In that case, Article 19 can also be suspended. Clear? But not in case of ground of armed rebellion. Clear? See, next feature is most of the fundamental rights are available against the arbitrary action of state. Arbitrary action of states. What does it mean? Means fundamental rights are there to protect the citizens from the arbitrary action of the states. Means state cannot enjoy unlimited power. There are checks and balance on the power of states. So most of the fundamental rights are against the arbitrary action of the states. Means state should exercise its power within the limitation. There is no provision of unlimited exercise of power. Next feature are, see, some fundamental rights are negative in nature and some fundamental rights are positive in nature. What does it mean? Some fundamental rights are negative in nature. What does it mean? It's place restriction on the authority of the state. It prohibits state to do something arbitrary. For example, state cannot detain a person illegally. So it is putting limitation on the authority of the state. So when fundamental right puts restriction on the authority of the state, then it is called as negative in character. And some fundamental rights are called as positive in nature. Why positive? Because they are giving some special provisions to the citizens, some special privileges to the citizens, which citizens enjoy. For example, right to freedom of speech, take a right to form association. These are the privileges to the citizens. So these fundamental rights are positive in nature. But on the other hand, some fundamental rights are negative in nature. Why? Because these rights putting restrictions on the power of the state or the authority of the state. Clear? Another feature is fundamental rights are protected and guaranteed by the Supreme Court. Means any aggrieved person can directly move to Supreme Court in case of violation of fundamental right. Clear? You can directly move to Supreme Court. There is no necessity to move through the way of appeal from the lower court, then high court to Supreme Court. You can directly move to Supreme Court in case of violation of your fundamental right. Clear? And last but not the least, the important feature is fundamental rights are not sacrosanct. Fundamental rights are not sacrosanct. What does it mean? Fundamental rights are not sacrosanct. Means these are not permanent rights. Not permanent rights. Means they can be curtailed or repealed by the parliament, but only through constitutional amendment without destroying the features of basic structure. Clear? Means fundamental rights can be curtailed or repealed by the parliament through constitutional amendment, but without destroying the basic structure of the constitution. Clear? So these are the some important features of the fundamental rights which you are supposed to learn. Any doubt? Now we will be studying all the articles in detail from article 12 to 35. So now come to first article 12. See, article 12 deals with the definition of the state. Definition of state. It defines what state consists of, what organs or what bodies. And in this article, it says that the state will include government and the Parliament of India, government and state legislature, all the local authorities. All the local authorities means Panchayati Raj institutions, urban local bodies or municipalities, district boards, etc. As well as statutory body and non-statutory body. Statutory body and non-statutory body. What is statutory body? Those bodies which are made by the act of parliament or state assembly. These bodies are called as statutory body. For example, you can give the example of CVC, Central Vigilance Commission. Clear? Yeah, you can give the example of NHRC, National Human Rights Commission. These bodies are the statutory body. So they also come under the definition of the state. You can write down. Statutory body means those body which are being made by the either parliament or the state assembly. And non-statutory body, for example, CBI. Non-statutory body means those body which are formed by the executive resolution. You can write down executive resolution, or you can say formed by the government of the day directly. For example, CBI. CBI is not a statutory body, it is a non-statutory body because it has been made by the executive resolution. There is no act for the CBI. Clear? So all those statutory and non-statutory body will also come under the definition of the state. And also, if any private body is acting as an instrument of the state, in that case, that private body will also fall under the definition of the state. Any private body, if it is acting as an instrument of the state, then it will automatically fall under the definition of the state under Article 12. It doesn't matter whether it is private or public. If it is a private body and it is acting as an instrument of the state, then it will automatically be under the definition of state under Article 12. Clear? Now come to Article 13. See, Article 13 deals with the laws made by the parliament and it's empower the judiciary. Article 13 empower judiciary for judicial review. For what? For judicial review. What does it means? Means Article 30 empower the Supreme Court as well as High Court to review the law made by the legislature, to check whether these laws made by the legislature are consistent with fundamental rights or not. If the laws made by the parliament are not in consistency with the fundamental right, then judiciary will declare this law as void or null. If any law made by the parliament is not in consistency with the provisions of fundamental rights. Suppose government made a law which is curbing the right to equality, the right to freedom. Then judiciary have the power to declare that law as null or void. Means that law will not be implemented for any fundamental right. Suppose legislature are making laws which is against the right to life, then judiciary has the power to declare that law as null or illegal. So this gives the concept of judicial review. So Article 13 also provides for the doctrine of judicial review. But remember, the word judicial review is not mentioned anywhere in the Constitution. Judicial review is not mentioned anywhere in the Constitution. And also both High Supreme Court as well as High Court. Supreme Court under Article 32 and High Court under Article 226 have the power to review the law made by the legislature. Means both Supreme Court and High Court have the power of judicial review. Clear? Now we'll be moving towards Article 14. Yes. Article 14 to Article 18 talks about right to equality. Right to equality from Article 14 to Article 18. So we will be discussing Article 14. See, Article 14 talks about two things. First one is equality before law. And second one is equal protection of law. Equal protection of law. See, in prelims they also ask a question in which many aspirants got confused. Equality before law is borrowed from which constitution? Yeah, which country? No, it's Britain. See, equality before law. Here is B, and in Britain there is B. So by this way you can remember equality before law is borrowed from Britain, and equal protection of law is from USA. So you won't get confused now. Equality before law is borrowed from Britain, and the remaining one means equal protection of law is borrowed from USA. See, what does equality before law means? It means two things. Equality before law means no one is above law. No one is above law. Any person. What does it mean? Means there will be absence of special privilege. Absence of special privilege. Isn't it? See, if no one is above law, it directly means there is no special provision for anyone in the law. If no one is above law, what does it mean? It means that there is no special privileges for anyone in the favor of any person. So equality before law means no one is above law. Law will be same for everyone. Means there will be no special provision in the favor of any person. And what does equal protection of law means? Equal protection of law means equality of treatment under equal condition or equal circumstances. Equality of treatment under equal condition or equal circumstances. Mean equal protection of law depends on the circumstances in which law is applied. It depends on the condition. And equality before law means no one is above law. There would be no special privileges for any person. There will be absence of special privileges in the favor of any person. That is equality before law. And equal protection of law means it will depends on the circumstances in which law is being applied. So it gives equal protection in equal circumstances. Means if circumstances for any person would different, then the treatment of law would be different for that person. But in equality before law, it doesn't mean. Clear? Now come to article number 15. See, article 15 talks about prohibition on discrimination. Prohibition on discrimination means state shall not discriminate its people on 5 grounds. Okay. First one is religion, means state shall not discriminate on the basis of religion. Second one is race. Third one is caste. Fourth one is sex or gender. And fifth one is place of birth also. Clear? So, there is prohibition on discrimination on the basis of religion, race, caste, sex or gender as well as place of birth. Clear? Means state is prohibited to discriminate on the basis of this ground. But there are few exceptions to this law. And what are those exceptions? See, Parliament can make special laws for the women because women are marginalized in Indian society. So to bring them into the mainstream, to ensure the equity in the society, to ensure the equality in the society, some special law are required for the parliament because women are vulnerable in the society. So there is exception for the women as well as also for the child. We have many laws which favor the child. For example, free education for the children under 6 to 14 years of age is a fundamental right under Article 21A. So a state can make law to favor these marginalized section. Also, if for the socially and economically backward section, means those people or those section which are socially and economically backward, Parliament can make a special law for them. Clear? Also, SC and ST, they are also vulnerable. They are also marginalized in Indian society. They are suffering from various kind of atrocities. So to protect these vulnerable groups, to ensure the equity in the society, to ensure the equality, Parliament can make laws, special laws for these vulnerable section. Clear? Now we will be moving to Article 16. See, Article 16 provide equality of opportunity in matter of public employment. Equality of opportunity in matter of public employment. Here the term public employment is important. Clear? Means it provides equal opportunity to all the people when it comes to the matter of public employment, means government employment, government job, जिसके लिए तुम लोग प्रिपरेशन कर रहे हो. So there is equal opportunity, there is equality of opportunity to all the people in case of public employment. Means anyone can apply for the government job, there would be no discrimination. But in this law also there are few exceptions. There are mainly two exceptions in this law given in Article 16(3) and Article 16(4). 16(3) is on the basis of residence. Clear? And 16(4) is on the basis of social and economic backwardness. Earlier there was only social backwardness, but after 10% reservation of EWS, under 103rd constitutional amendment, now it also consider economic backwardness also. So there are two exceptions. On the place of residence means, see, in any state only parliament can make law for the resident of that state to occupy few position in that state on the basis of residence, but the law will be made by the parliament. Why? Because any law regarding the fundamental right can be made only by the parliament, though it has the provision for the residence as a condition to occupy the position in any state. But since it is a fundamental right, so the law will be made by the parliament only. Clear? Or any doubt? Parliament has the power to reserve few position for the specific resident of that state. For example, in case of UP, in case of UP, yeah, in case of any particular state, any particular position can be reserved for the resident of UP only. But that law would be made by the parliament. UP government cannot make the law. Even any state government cannot make law on the fundamental rights. Clear or any doubt? This is very confusing. Clear? Now I am moving to second part. Means state can make a special provision for the reservation of the people who are backward class of citizens, whether they are socially backward or they are economically backward, if they are not adequately represented in the service of the state. Clear? Earlier it was only social backwardness, but now it also considers economic backwardness. So in Lakshmikant, in old editions of Lakshmikant, you will find only social backwardness. But after 103rd constitutional amendment, which gives 10% reservation to economically weaker section, Article 16(4) also consider economic backwardness as the backwardness for the reservation of public employment. Clear? Now we will be moving to Article 17. See, Article 17 talk about Abolition of untouchability. Abolition of untouchability. And its practice in any form and made it a punishable offense under the law. Clear? Article 17 talks about abolition of untouchability and the practices of untouchability in any form, whether in physical form or mental form, or in any form if you are practicing untouchability. Suppose you are not allowing entry of the Dalit people or scheduled caste people in any place, in any public place, then it is a punishable offense under the law. So Article 17 talks about the abolition of untouchability and practices of untouchability in any form and have made it a punishable law. Clear? And since, see, in India, even private persons also practicing untouchability. Untouchability is practiced by not only state but also by the individual person, isn't it? Before independence, even government was also practicing untouchability against the Dalit people or scheduled caste people, and private individuals were also practicing untouchability. Clear? So this fundamental right is also against the private individuals, not only against state. Why? Because it is the duty of the state to take necessary action against those private individuals who are practicing untouchability. And for abolition of untouchability, Parliament has made law in 1955 named as Untouchability Offences Act 1955, which was later renamed in 1976 as Protection of Civil Right Act. And under the Protection of Civil Right Act, if any person is found practicing untouchability in any form, then he would be imprisoned for up to 6 months or rupee 500 or both. Clear? And if any person is found practicing untouchability, then he would be disqualified to contest election either for parliament or state legislature. Clear? But remember one thing, untouchability has not been defined in the constitution. That is a very vague term. Untouchability has not been defined in constitution, even not in the protection of civil rights acts. It depends on the interpretation of the judiciary. Constitution has only provided that ki untouchability should be abolished and its practice in any form should be abolished and made it a punishable offense. But constitution has not defined untouchability anywhere in the constitution, nor it is defined in the act also, protection of civil right act. Clear? Now come to article 18. Article 18 talks about abolition of titles. Abolition of titles except two titles. Which two titles? Military titles and academic titles. Clear? And there are mainly two provisions in the article 18. I am going to explain that. See, article 18 prevents state means government of India or any state under the definition of Article 12. A state cannot confer or give any title to any person except in case of military and academic. Means only military title and academic title can be awarded to any person. Clear? Also at the same time, it also prohibits any citizen of India to take any title from any foreign country. Means it is prohibiting both government of India as well as citizen of India. Means state cannot confer any title to the citizen of India except military title and academic title. And at the same time, it also prohibits citizens to take any title from any foreign country. Clear? Now, the next topic is from Article 19 to 22, that is right to freedom. Article 19 to 22, that is right to freedom. How many of you have remembered the articles which are given in fundamental right? I have asked you now to remember from Article 14 to 32. All the rights under Article 14 to 32. You have to learn it. How many of you have learned it? Anyone who have learned all the articles from Article 14 to 32? No one. Seems too busy and having too hectic schedule. Huh? Of some unnecessary work, that's why not able to focus on your studies. Am I right? Or anything else? You guys are preparing for UPSC, no? This is not a one day exam in which you will start studying before 1 month and you will qualify. It is a gradual process of learning. So consistency is required in your studies for at least 15 to 18 month consistency. You can skip 2, 3, 4 days if you are getting bored. But you are supposed to learn these articles because these articles can be used in answer writing also. And apart from an aspirant of UPSC, you are also a citizen of India. So you must be aware about what are your fundamental rights, which are you enjoying. That's the way to self-empower yourself. You must be aware about these rights by uh, being a citizen of India. And while enjoying these rights, you must also remember your duties also. And you guys are a civil service aspirant, so you are supposed to learn all these things. I hope you will learn all these fundamental rights from Article 14 to 32 by tomorrow. Am I hoping something very difficult? Is it doable or not? You can learn it, no? So I hope by tomorrow all of you will learn it. Clear? Now I will be dictating some important points. Write down in your notes. Okay. And while I am discussing these topics or any topic in the class, just try to remember these diagrams. Okay. You'll be able to revise it at the last moment. Okay. We are also giving booklet, but that booklet is only for revision purpose. So also make notes in your own hand. That is very necessary because you won't be able to revise entire notes. You will get a very large number of pages in your notes in all the topics, whether it is polity, economy, history, environment, disaster management, society, ethics. So you won't be able to revise all these bulky booklets or these bulky books at the last moment. So it is advisable to all of you to make short notes of whatever you are reading. Make your own content from the notes and book to structure or frame your answer. Though it is a gradual process, you will learn it gradually. You won't be able to learn it in a single day. It is an art. Okay. An art can be learned only in gradual manner. It cannot be learned in one day. No? You might have taken the drawing classes in your school. I was not able to draw the diagram of mango for even 1 month. So I was skipping the class of periods of drawing. And I still regret that skipping of class because I am not able to make a good diagram of Indian map or world map. And due to some reasons, I could not practice drawing the maps of India as well as world. So drawing every subject which you are learning in your school, that is also important. But at that time, we even our parents were not aware that what is the importance of these topics. So most of the parents focus only on maths and science subject, isn't it? Due to the lack of awareness. And in Indian society, if you are a humanities student, you are considered as below average student. It doesn't matter whether you are very excellent in your subject, you are scoring above 90%, 95%. If you are a humanities student in your school, then you are considered as a below average student. Is it true? But that doesn't mean if you are from humanities background, then you are a below average student. Humanities are also required as much as science is required for the growth and development of any nation. That's why even some IITs are offering courses on humanities subject. In this era of globalization, you should be a multidisciplinary person to survive or to grow. You can survive without being multidisciplinary, but if you want to grow, if you want to get succeed, then it is not possible to grow by being a specialist in a single subject. And that's why UPSC become difficult. Though it is not so difficult, it becomes difficult because of its multidisciplinary approach. Clear? And I hope that by tomorrow you all will be able to learn all the fundamental rights given in Article 14 to 32. Okay. Now come to the write down. Fundamental rights are given in part 3 in Article 12 to 35. Part 3 in Article 12 to 35. Some of the subject matters some of the subject matters of fundamental rights are borrowed from US Constitution. Of fundamental rights are borrowed from US Constitution. Part 3 of Constitution is described as Magna Carta of India. Part 3 of Constitution described as Magna Carta of India. Next, fundamental rights are justiciable in nature. Fundamental rights are justiciable in nature means a person can move to court. A person can move to court in case of violation. A person can move to court in case of violation. Fundamental rights are named so. Fundamental rights are named so because they are guaranteed and protected by the Constitution, which is fundamental law of the land. Which is fundamental law of the land. Next para. Motilal Nehru Committee had demanded Motilal Nehru Committee had demanded fundamental rights in 1928. Fundamental rights in 1928. In Karachi session 1931, under the presidency of Sardar Vallabhbhai Patel. In Karachi session 1931, under the presidency of Sardar Vallabhbhai Patel, a resolution on fundamental right was passed. A resolution on fundamental right was passed. Next, difference between fundamental right and ordinary right. Difference between fundamental rights and ordinary rights. Presidentship of Sardar Vallabhbhai Patel. Right. Ordinary rights are protected by ordinary law. Ordinary rights are protected by ordinary law. Fundamental rights are protected by Constitution. Whereas fundamental rights are protected by Constitution. Second, ordinary rights may be changed by ordinary process of law. Ordinary rights may be changed by ordinary process of law making. Ordinary rights may be changed by ordinary process of law making. Whereas fundamental rights may only be changed by constitutional amendment. Constitutional amendment without destroying the feature of basic structures. Without destroying the basic structure of the Constitution. Next para. Originally, there were 7 fundamental rights in the Constitution. Originally, there were 7 fundamental rights in the Constitution. ठीक है? And write down all the 7 fundamental rights given in your booklet. ठीक है? Leave the space for that and write from next para. ठीक है? Write down all the fundamental rights. ठीक है? And leave the space. Write down from the next para. However, the right to property was deleted from the fundamental right. However, right to property was deleted from fundamental rights in 1978 by 44th constitutional amendment. In 1978 by 44th constitutional amendment. It is made a legal right under Article 300A. It is made a legal right under Article 300A and Part 12 of the Constitution. 300A and Part 12 of the Constitution. See, for state PCS, you also have to learn such kind of facts because they are into habit of asking such facts which we generally ignore while preparing for UPSC. But in state PCS, you will always get such factual questions. So if you are preparing for both, then you have to learn these facts also. Clear? And also in introduction, if you are able to learn these facts, then you can use these facts in your introduction of your answer. So whether you are preparing for UPSC or state PSC, in both the cases, you are supposed to learn these facts. Clear? Now come to the next features of the fundamental rights. And get into habit of writing also because you are supposed to write 4000 words within 3 hours. And with a gap of few hours, you have to again write 4000 words. Means get into habit of writing 6000 words in a day with a gap of 2 or 3 hours. Also, it is a gradual process. Don't just sit down in the next day and start writing 6000 words. कि सर ने बोला था तो now I will do it. सर ने बोला है to get into habit of writing it. ये नहीं कि कल से स्टार्ट कर दिया है. ठीक है? अभी 100, 150, 200 वर्ड लिखोगे that's enough. Even make short notes, that is enough as of now. But gradually you will have to develop the habit of writing 4000 words within 3 hours. But don't just start it from tomorrow. ठीक है? कि सर ने बोल दिया तो I will do it. Clear? Write down the features. Okay. Some of the rights like Article 15, 16, 19, 29 and 30. Article 15, 16, 19, 29 and 30 available only to the citizens of India. Available only to the citizens of India. While other rights are available to all person, whether citizens, foreigners, or legal persons like corporation or companies. Whether citizens, foreigners, or legal persons like corporation or companies. Like corporation or companies. Second, fundamental rights are not absolute but qualified in nature. Fundamental rights are not absolute but qualified in nature. means not absolute but qualified in nature, means state can impose restrictions on fundamental right, means state can impose restrictions on fundamental rights. Next, except Article 20 and 21, except Article 20 and 21, all other fundamental rights, except Article 20 and 21, all other fundamental rights can be suspended, can be suspended during operation of national emergency, can be suspended during operation of national emergency. Next, Article 19 can be suspended. Article 19 can be suspended only when emergency is declared on the ground of. Article 19 can be suspended only when emergency is declared. Emergency is declared on the ground of war or external aggression. War or external aggression, and not on the ground of armed rebellion. And not on the ground of armed rebellion. Armed rebellion. Next, most of the fundamental rights are available. Most of the fundamental rights are available against the arbitrary action of state. Against the arbitrary action of state. Next, some fundamental rights are negative in character. Some fundamental rights are negative in character. Some fundamental rights are negative in character, means they place restrictions on the authority of the state. They place restrictions on the authority of the state. On the other hand, some fundamental rights are positive in nature. On the other hand, some fundamental rights are positive in nature. Means they give privileges to the persons. Means they give privileges to the person. Next, fundamental rights are defended and guaranteed by the Supreme Court. Fundamental rights are defended and guaranteed by the Supreme Court. Means Parliament can, means any person, या any aggrieved person लिखो, means any aggrieved person means any aggrieved person can directly go to Supreme Court, can directly go to Supreme Court can directly go to Supreme Court in case of violation of fundamental rights. In case of violation of fundamental rights. Next, fundamental rights are not sacrosanct. Fundamental rights are not sacrosanct. Means Parliament can curtail or repeal. Parliament can curtail or repeal fundamental rights by constitutional amendment. Fundamental rights by constitutional amendment without destroying the basic structure of the constitution. Without destroying the basic structure of the constitution. Clear? So these are the important features which you need to learn. Now come to Article 12. Article 12 provides the definition of the state. Article 12 provides the definition of the state. It includes Government and Parliament of India, Government and Parliament of India, Government and State Legislature, State Government and State Legislature, local authorities including Panchayati Raj institutions, local authorities including Panchayati Raj institutions, urban local bodies, district boards, etc. Urban local bodies, district board, etc. Other statutory and non-statutory bodies. Other statutory and non-statutory bodies. Clear? Next, even a private body working as instrument of state, even a private body working as an instrument of state falls within definition of state under Article 12. Falls within definition of state under Article 12. Now come to Article 13. Article 13. Article 13 declares that all the laws that are not consistent with the fundamental rights, all the laws that are not consistent with the fundamental rights shall be declared null or void. Shall be declared null or void. It provides for the doctrine of judicial review. It provides for the doctrine of judicial review. Though the word judicial review is not mentioned in the Constitution. Though the word judicial review is not mentioned in the Constitution. Next para. Supreme Court under Article 32 and High Court under Article 226. Supreme Court under Article 32 and High Court under Article 226 can declare a law unconstitutional. Can declare a law unconstitutional on the ground of violation of fundamental right. On the ground of violation of fundamental rights. Next, right to equality, Article 14 to 18. Right to equality, Article 14 to 18. Write down. Article 14 says that Article 14 says that state shall not deny to any person. State shall not deny to any person equality before the law, equality before the law, or the equal protection of the law. Equality before the law or the equal protection of the laws within the territory of India. Within the territory of India. Next, Article 14 aims to establish Article 14 aims to establish the equality of status and opportunity. Aims to establish the equality of status and opportunity as mentioned in the preamble of Constitution. As mentioned in the preamble. Next, equality before law means no one is above the law of the land. Equality before law means no one is above the law. That is absence of any special privileges to any person. No one is above the law, that is absence of any special privileges in favor of any person. It has been borrowed from British Constitution. It has been borrowed from British Constitution. Next, equal protection of law means equal protection of law means equality of treatment, equality of treatment under the equal circumstances. Equality of treatment under the equal circumstances. It has been borrowed from the US Constitution. It has been borrowed from the US Constitution. Now come to Article 15. Article 15 prohibits the state from Article 15 prohibits the state from discriminating any citizen on the ground of any religion, on the ground of religion, race, caste, sex, religion, race, caste, sex, place of birth. There are few exceptions like this article also empowers the state to make special laws This article also empowers the state to make special laws for women and child, for women and child, socially and economically backward sections, socially and economically backward sections, scheduled caste, scheduled tribes, scheduled caste, scheduled tribes, in order to bring about the equality, in order to bring about the equality. Now come to Article 16. Article 16 provides the guarantee of equality of opportunity, provides the guarantee of equality of opportunity in matters of public employment, in matters of public employment. There are few exceptions like Article 16.3, like as per Article 16.3, residence qualifications, residence qualification may be made necessary, residence qualification may be made necessary in case of appointment under the state for particular positions, in case of appointment under the state for particular position. However, however, such laws can be made by the parliament. However, such laws can be made by the parliament. Clear? Next, Article 16.4 empowers the state. Article 16.4 empowers the state to provide for the reservation, to provide for the reservation of appointment, reservation of appointment or post in favor of backward class of citizen, in favor of backward class of citizens which are not adequately represented, which are not adequately represented in the services of the state. In the services of the state. Next, Article 17. Article 17 abolishes the untouchability. Article 17 abolishes the untouchability and its practice in any form, and its practice in any form is made punishable under the law, is made punishable under the law. However, the term untouchability, however, the term untouchability has not been defined in the Constitution, Term untouchability has not been defined in the Constitution. Parliament passed Parliament passed Untouchability Offences Act 1955. Parliament passed Untouchability Offences Act 1955 and renamed it as Protection of Civil Rights Act in 1976 and renamed it as Protection of Civil Rights Act under in 1976. Next, under the Protection of Civil Rights Act 1955, under the Protection of Civil Rights Act 1955, offences committed related to untouchability, offences committed related to untouchability are punishable offense, are punishable offense, are punishable offense either by imprisonment of 6 months up to 6 months, either by imprisonment of up to 6 months or fine up to rupee 500 or fine up to rupee 500 or both. Also, any person, also any person convicted of the offense of untouchability, convicted of the offense of untouchability is disqualified, is disqualified for election to the parliament or state legislature, disqualified for election to the parliament or state legislature. Article 17 is also available. Article 17 is also available against the private individuals. Against the private individuals. Next, come to Article 18. Write down. Article 18 prohibit the state to award any title. Article 18 prohibits the state to award any title except military and academic, award any title except military or academic. Also, it prohibits the Indian citizens. Also, it prohibits the Indian citizens from receiving any title, from receiving any title from the foreign states, from the foreign states. Clear? So, on Monday we will continue from the right to freedom. Okay. Any doubt?